Good afternoon, everybody. Let's go ahead and get started. Good morning, good afternoon. I'm going to introduce our speaker today. Michelle Garnett McKenzie is the Deputy Director at the Advocates for Human Rights. She leads the organization's research, education, and advocacy team. She joined the staff in '99 as an attorney representing asylum seekers and detained immigrants, and she later managed the asylum, detention, and walk-in clinic projects. Michelle serves on the national leadership team of the Immigration Advocates Network and on the Minnesota Coalition Against Sexual Assault Public Policy Committee. She is a member of the American Immigration Lawyers Association and is admitted to practice in the state of Minnesota. Prior to joining the Advocates, Michelle was in private immigration practice and served as a judicial law clerk for the Executive Office for Immigration Review in both Arizona and Nevada. She received her JD cum laude from the University of Minnesota Law School and her BA cum laude from Macalester College. Michelle will be speaking to us today about immigration law. She has said that questions, feel free to ask them at any time. You don't have to wait until the end. So please help me welcome Michelle.
For those of you on the webinar, you can see me, but for the rest of you, that's the last. I am here. So if I don't call on you, wave hi because I can't see you over the computer. But thank you so much for inviting me to be here today. This is a full room and a full topic, right? There's a lot going on in immigration. It's impacting us living here in Minnesota, and it has for generations. And so I hope that we can have a good discussion this morning or this afternoon about where we are right now, how we got to where we are, and how that's playing out in our communities. As introduced, I'm at the Advocates for Human Rights. The Advocates is a Minnesota-based nonprofit. We are a volunteer-driven organization dedicated to implementing internationally recognized human rights standards. We do that by engaging volunteers, so no hints out there, but hints, I guess, are an invitation is there to really build civil society, reinforce the rule of law. We work in areas including legal reform on violence against women, and we do a lot of work with partner organizations around the world to strengthen legal systems. We also engage in efforts to abolish the death penalty worldwide, to engage the international human rights mechanisms in holding violators accountable, and of course in protecting the rights of immigrants and refugees right here in our community. We've worked extensively on the elimination of human trafficking and legislation that's come through the state, and that intersects as well, so if there are questions around that as we go, I'm happy to try to address that. But primarily what I'm here for is to talk about where things are affecting Minnesota's immigrants and refugees. Now, the Advocates represents, through our free legal services program, close to 700 individuals every year in complex immigration matters, primarily asylum. I'll describe a bit more what that is as we go along, but also representing people detained in immigration custody. That's in addition to the 650 folks. About 200 of our clients are in immigration court and deportation proceedings. 85% of our clients are represented by volunteer attorneys. We're a pro bono program. And again, no hints, but you're welcome. And we also have an Equal Justice Works Fellow primarily or exclusively devoted to unaccompanied alien children, UACs, as they are affectionately known in the immigration system, and a Robina Fellow from the U of M dedicated just to our detention work, which is growing fairly precipitously right now. So before I dive into kind of where we're at, I just want to set up where I'm coming from. You've heard it. I'm at some place called the Advocates for Human Rights. So that conjures to mind some assumptions about what we mean. international human rights law really balances two things. Balances national sovereignty and our obligations as a nation to protect the human rights of everyone who is within our community. So our framework is really looking at both of those components. There is a role for national boundaries and borders, even though for 200,000 years of human history, people have moved without those. So we can see that there is a little bit of tension, and it's no surprise that, especially in a globalized world where we can get on an airplane or a boat or drive a car, we are moving a lot more than we ever have before. But we're moving for many of the same reasons, of course, to find a mate. I know at least one person in this room has an international spouse. So moving around to find friends, mates, moving around to find adventure and food, moving from flood or famine or fear. Those are things that have been done for millennia and will continue to be done. I mean, there's some of the same motivators for migrants today. But as I said, national boundaries are definitely a newer phenomenon. Now, immigration is also not without politics. I think that's evident. But the policies, the laws that have arisen and that I'm going to be talking about today are really the product of several subsequent administrations, a very bipartisan effort over decades, and are more in relation to how we see ourselves as a community, how we define ourselves as Americans, how we figure out who's in and who's out of this collective. Certainly Congress's decision to enact or not legislation is purely political, but that's Congress. The immigration system that we work in and the reason we have immigration laws is something that is really part of our nation. So today I want to go over a few things with you. One is to give an overview of recent developments. They are important and they are significant. In 20 years of doing this, this is the most up in the air, unpredictable time I've experienced representing clients or trying to understand what's going on. And so I want to acknowledge that. But I also want to give a snapshot of how we arrived here, because it didn't come out of the blue. It didn't just suddenly change. In fact, in our laws, nothing has changed. In our policies, very little has changed. This is very much a cumulative effect of decades of policy. But before I do that, I need to back up and give just a little bit of framework around Immigration 101. And I do welcome questions. I'm going to try to keep my eye open for the people in the online audience. And if you do have a question, I'll try to repeat it as best I can so that people can understand what you're asking if they're staying at home. So immigration law is not that complicated in some ways. How do you get in and how can you get kicked out? Right? Those are sort of the two main elements. Another way of looking at it is, are you a citizen or an alien? There aren't in-betweens. It is like being pregnant, right? It can't be a little bit. You either are a citizen or you are an alien. And that is the terminology our federal immigration law uses to describe non-citizens. It is an approach that has underpinned our immigration laws and our discussion of who's a national of the United States, who's a citizen, versus who's an alien, since our very founding and even before. So those are, sometimes jarring words when I'm talking about aliens. Why wouldn't you say something nicer? Non-citizens, immigrants. Well, why don't we collectively say something nicer if we want to say something nicer? That's our public policy. And that's really where the whole system revolves. Immigration Legal enforcement is designed to figure out who's staying out, who's getting kicked out, who should be left in. That is what the system is set up to do. That's what immigration enforcement does. That's what adjudications does. That's what the courts do. It doesn't decide who should be in that system. So who gets in? Well, statute, of course, controls in this federal 8 U.S.C. controls everything in our little immigration world. And it talks about people who can be excluded based on health status, based on criminal conduct, not criminal convictions necessarily. One can be excluded from the United States because one admitted to the essential elements of a crime. Security grounds, of course, national security. Being a public charge remains grounds of inadmissibility. So if you are likely to become a public charge in the United States, likely to go on to public assistance, use cash assistance, you're inadmissible. And people with immigration violations are also inadmissible. Now, there might be waivers for some of these. For other things, there is no waiver. Right? There are certain grounds of inadmissibility that are permanent and unmovable. And that has grown as we've gone along. Another component of getting in is how are you getting in? What are you getting in as? If you're lawfully admitted to the U.S., what's your status? We talk about that all the time in immigration law. So the term immigrant, in true fashion of federal legislation, includes every alien except one who's in the non-immigrant classifications. I love this. Non-immigrants are immigrants. Non-immigrants are aliens who are coming to the U.S. just temporarily, for a limited purpose, limited time. They might be visiting. They might be students. They might be shopping at the Mall of America. They might be playing baseball. They might be coming here to work at a company. They might be coming here to invest. They may be somebody who's coming for a long time or a very short time. We can see someone admitted as a non-immigrant for the purpose of attending a conference, and they're allowed in for 2 days. And we can see somebody coming into the U.S. as a graduate student, a doctoral student, for the duration of their studies, which might be really perpetual. So as long as they're maintaining student status, they could be in that. These are non-immigrants, defined by their intent to immigrate, permanently live here, or not. It is my single favorite term, perhaps with the exception of OTM, which I'll explain if anybody wants to know OTM. Immigrants are the rest of the people coming into the U.S., either legally or without lawful status. They're a person who is coming to acquire the status of lawful permanent resident or permanent residence in the U.S., a green card, a person who's coming here intending to live here, to make this their permanent residence. They're not coming just to study, just to work for a short period of time. They're coming here to reside. But if they leave for a year, they abandon that status. Green cards are not permanent. They are indefinite. They can be given up. An immigrant is somebody who can come in either subject to numerical limits based on family unification, employer sponsorship, the diversity visa lottery. I was surprised to learn when I started doing this that we actually have a lottery for green cards. Any guesses why? Because of historical patterns of migration that excluded whole categories of people from immigrating to the U.S. to bring diversity into the immigration system. So family-based, employer-based, diversity visa, those are the three main ways you can get a green card. You might also be able to get one if you're the immediate relative of a U.S. citizen, spouse, parent, or child of a U.S. citizen. If you've been granted refugee status, an immigration judge has allowed you to stay here because of the long period of time you've lived in the U.S., an exceptional and extremely unusual hardship that may arise if you're deported to your family here, and for a few various miscellaneous categories. But absent that, you don't get a green card. Why is that important? A green card, permanent resident status, is the basis for citizenship, for naturalization. You can't naturalize if you don't have a green card. And so we often hear people saying, well, he married a U.S. citizen. Isn't he a citizen? No. There's a step. First, you must have that citizen spouse file papers for you. They might not want to. You might not be able to afford it. Maybe you are a public charge. There may be a whole range of reasons why they can't even file that. And you have to be admissible, to not be barred. And if you get that, then you can become a permanent resident. And only after years following that can you get your citizenship. And again, there's an application, a fee, a process, fingerprints, background checks, all of that. We do offer some humanitarian protection. The U.S. Refugee Admissions program allows certain individuals from certain countries to come to the United States if they've been recognized as refugees and to come in and then become permanent residents and citizens. It's a very narrow program I'll talk more about. You could be granted asylum here in the United States. You could be granted some emerging areas of protection for crime victims or human trafficking victims. They're new, about 10 years old that we've been working with these, and they are changing in different ways how we perceive immigrants in the courts. We've had several really disturbing reports from clients I've done intake with, saying they attempted to report a crime to local police or prosecutors and were told, we don't believe you, you're only reporting the crime because you want a visa. We've had reports through Minneso of courts saying, I will grant your OFP, but only if you agree not to file for a U visa, file for protection here in the U.S. Because I don't want you doing an end run around the immigration system. There are different interpretations of how this is meant to be, how this law has come into being in federal immigration law, and what its purpose is here. And I think one of the challenges as a judicial system we have is making sure that we're stepping back and looking at what we're charged with, adjudicating, and what we're not. So this has left us with this system. This is the legal immigration system. It's pretty self-explanatory. I don't see any, yeah, it's a joke. It is a joke. The title of this cartoon is What Part of Legal Immigration Don't You Understand? Right? This is a pretty crazy system because, as I mentioned, there are some numerical limits on immigration. There are waiting lists that have arisen because of that. There are categories and preferences and routes that exist for some people and not for other people. Not everybody makes it into the United States. There is not a line to just get into. That would be nice. It is how it existed for many generations, but only for a few nationalities. But it's not what actually happens. This is a much more accurate representation of the entry system into the U.S. So how do you get out? Okay, you got in. You might get in legally through your green card, or you might not. If you came into the United States without permission and you're here, any alien who's not in lawful status is subject to detention and subject to removal from the United States. Purely, it's a very broad authority, and it's really in the discretion of ICE, the Immigration and Customs Enforcement, federal government, to decide its capacity and its how many people can be detained at any given time. But there's no legal limit. If you are not in lawful status or not believed to be in lawful status, you can be detained. There is a quota. Federal appropriations law requires that 32,000 or 34,000 detention beds be be available on every day and be filled on every day. So there is sort of a quota for the number of people we decide to keep in detention. But that's more to do with appropriations and the budget and who's getting paid for those beds than it is for public policy. People could be removable because they're here without any status at all. There are undocumented people in the U.S. There's an estimated 11 million folks who have no papers in the U.S. About 95,000 are estimated to live in Minnesota. A person might be undocumented because they entered without status or they overstayed one of those statuses. They came in to study and didn't keep paying their tuition, came to work at one employer and left that job and went to another. All of that would violate their status. People also can be removable for a variety of immigration misconduct, like smuggling, marriage fraud, a whole range of criminal convictions, immigration document fraud, false claims of citizenship, terrorism, and unlawful voters. The statute goes in that order. I find it interesting we sandwich terrorism between false claims of citizenship and unlawful voting, but we do. Those are all taken as very serious. A false claim to U.S. citizenship is pretty much the end of your immigration case. It is a permanent bar and it is mandatory expulsion, except if you are afraid of persecution or torture, but you cannot get around that. There's no waiver of a false claim to citizenship. So an admission made on an I-9 form, when you're signing in to check whether you're lawfully authorized to work, could potentially be an admission of unlawful citizen or unlawful claim to citizenship. Registering to vote when you sign up for your driver's license, if you're a green card holder, is illegal. These kinds of things, we build in all these systems that make things easier in some ways and then may sweep people in by mistake. So how do people get removed from the U.S.? The U.S. Immigration Court has jurisdiction over removal proceedings. This is an executive branch agency. It's part of the Department of Justice. It is a teeny tiny agency. You can find it in the Executive Office for Immigration Review in DOJ. We have now 3 judges. We had 2 for most of last year and received over 2,000 new filings at the Fort Snelling Immigration Court, which has jurisdiction over Minnesota, North and South Dakota. 2 to 3 judges, that 3-state area. Think about your own volume. Think how exciting it would be to do that with just 2 of you. And a couple of clerks, not really very, very many support staff. Overall in the U.S., 93,000 removal orders were issued last year. But ICE removed over 240,000 people from the U.S. So how did that happen? And this is one of the things that I think is mysterious to us. We would expect that people in removal proceedings, people being accused of being illegally in the U.S. and being removed from the U.S. would see a judge. Most don't. This past year, it was a little over half. Over the past 8 years, it had been about 2/3 of the people, 3.2 million people removed under the previous administration. About 2/3 did not see a judge. They were either subject to administrative removal because they were unlawfully here in the U.S., they had entered without inspection, had no status, and had been convicted of a category of crimes known as an aggravated felony. Or they were subject to reinstatement of removal. They'd been previously ordered removed and were back in the U.S., and so they just reinstated a prior order. Or they stipulated to their removal. The individual alien in custody agreed with an enforcement and removal officer to plea agreement, to agree to go, to waive any claims to stay, waive a hearing, and agree to their deportation. That is a pretty standard way of approaching any of the folks in detention and in deportation. Just you have no case, why don't you go? What's missing on here that you might expect to see in a court system is defense counsel, right? There is no public defender system in the immigration world. You do have the right to be represented, but only if you can afford representation. And it is there is no free legal service for it, except through those charities that exist throughout the U.S. We provide that. A number of other places here in Minnesota do. We are over-resourced in Minnesota compared to many of our neighbors with immigration lawyers, and there's probably about a dozen deportation defense free legal service attorneys for the state. We never have access to people in ICE custody before they negotiate stipulated removals. There's no assignment of counsel, so we don't see people unless and until they make it to the court. I want to touch on a factor that is driving the volume in the immigration system right now, and that is alluded to with the immigration quota, the detention quotas. In 1980, we had, on average, 54 people in detention, in ICE custody or INS custody at that point, at any given time. By 1990, we had 6,500, and you can start to see red spots. By 2000, we had 20,000 people on average per day in custody. And by 2010, we were up to 30,000. That's about when the quotas were inserted into the appropriations language for DHS. At the end of last fiscal year, September 30th, there were 45,000 people in ICE custody. But this does not include people in Customs and Border Protection custody, in 72-hour hold facilities along the borders. They're not counted in this. This is just people who are in custody in the interior awaiting either a removal hearing or deportation itself. That is a fairly extraordinary number of human beings in custody, and it is growing. We've seen pretty good expansion here in Minnesota. I think there's some negotiation to install bunk beds in some of the jails that are being contracted with, and there might be Candy-Ojai County might have just opened some holding facilities. So we're seeing a greater number of people in ICE custody here. You know, by definition, anybody in ICE custody is not serving a criminal sentence. They may be post-conviction, post-sentence, and turned over to ICE, but they're not, if they're in ICE custody, they're not serving a criminal sentence. These are all civil removal cases. The immigration court has now opened a detention, a bond docket, so that they can hear bond cases, but over the summer, we were routinely seeing people sitting for 6 weeks between apprehension and their first appearance in court, because there were just backlogs in the numbers. And that was their first appearance to make a claim for release on bond. That's a long time to be in custody without access to release on bond. ICE had, one of the changes that we have seen is that ICE has stopped setting a bond for most people and wants the immigration court to set that bond. So if you're waiting for a few weeks, that's really difficult. You don't have an end date. ICE custody doesn't end while proceedings are going on. They can hold people throughout proceedings. So if you appeal, it could be another year in jail. There's not there's not a sentence being imposed. There is also an aspect that really, I think, unnerved me and a lot of the asylum practitioners out there that started in about 2013, 2014, as more Central Americans were coming to the U.S. There was a real breakdown in civil society in Guatemala, El Salvador, and Honduras during that time. And we started to see many UACs, unaccompanied children, and moms traveling with young kids coming to the U.S. and actually going throughout the region, going to Mexico, going to Panama, going to Costa Rica, Nicaragua, all are countries of asylum, but coming also to the U.S. And to stem that tide, one of the approaches was really to let people know that they would be detained and be deported if they attempted to come to the U.S. The Obama administration opened a couple of prisons, both run by private prison companies, for families. So they're for moms with children. They are both in Texas now. There was one in New Mexico. There's another less, it's not a prison, it's more of a detention center in Pennsylvania. But it is one of those aspects that I think causes me to question where we're heading with this, because we don't typically imprison children in the United States. But we do. We've got several thousand families living in detention, 1, 2 years, and there's razor wire, there's sally ports. These are their schools. They go to classes, they get meals, but it is a prison system. That's something that really made us all kind of stop and think. Maybe some of the limits we were thinking were on in discretion weren't there. So where else is discretion happening? And now I want to turn to some of the current things happening in the immigration policy landscape. Probably the most publicized in the last month has been the end of the Deferred Action for Childhood Arrivals program, DACA. You see these smiling kids from United We Dream rotating through. Hopefully it won't make us seasick. United We Dream is a DACA kid-led initiative that is really changing in the way that immigration policy and politics are playing out in the U.S. But the Deferred Action for Childhood Arrivals program was terminated. On September 5th, the president announced that President Obama's plan to give temporary relief from being deported in the form of something called deferred action, which is a mechanism that has been used over and over by immigration in individual and in blanket cases over the years, that would be terminated. DACA was exclusively within the president's purview when he announced it and to terminate it. And DACA established a very narrow category for those who would be put essentially at the bottom of the deportation pile. Of the 11 million people who were in the U.S., they would be at the bottom. And because they were at the bottom, and Obama thought we probably won't get to them for a while, that was the thinking, they were issued work permission. That has begun to expire now. So new DACA applicants who were aging into the DACA program, you had to be at least 15, they no longer can enroll. Existing DACA holders can continue to work for the duration of their work permits, but those will begin expiring. And people who did not apply for DACA renewal by October 5th you can't renew anymore. The renewal date closed October 5th. Deferred action is really just one of the many exercises of discretion that exist. Alongside it is something called temporary protected status. Again, a sort of blanket determination that people can't return safely to where they're from, so they need temporary stays here along with temporary work permits. The most lengthy grant of temporary protected status was 1991. Liberians, about 1,000 Liberians in Minnesota have been on temporary protected status since 1991. If any of you were born before 1991, you can appreciate how not temporary that is. If you were born after 1991, your entire life has been spent on temporary status. That is given out in 12 or 18-month increments every year to terminate. This year, we expect it will terminate a number of temporary protected status countries have been crossed off the list. The biggest one coming down the pike involves Central American temporary protected status holders. There are about 300,000 people who are expected to lose status in the coming year as these terminate. That's a lot of people to add into that 11 million. Of people who don't have status, it's putting more people into that. Another area that has been on the top of the policy priority for this White House has been the refugee and asylum programs. This definition, outside the country of nationality owing to a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion, is the international and U.S. definition of a refugee. You have to meet this definition to be considered a refugee, to be given international protection at the global level, to be admitted to the U.S. as a refugee, to be protected for asylum. And this program has really been front and center of the critiques and cutbacks in the last 6 months. Worldwide, we are at a really crisis moment in the refugee community. There are over 21 million people outside their countries of origin owing to that well-founded fear of persecution today in the world. It's down slightly, but it still remains at historic highs. That doesn't count an additional 40 million people who are displaced within their country's borders. They don't count as refugees. They're internally displaced persons. There's nothing the world community really can or will do for them. Of that 21 million individuals living largely in refugee camps, in cities, informally in countries next door to where they fled, in people's couches and in relatives' homes, only about 125,000 were resettled worldwide in the past year. So that's a tiny, tiny fraction of that 21 million. Most of the 21 million are expected to go home, repatriate, as the first durable solution for the world's refugee crisis, or locally integrate, just eventually become nationals of, hopefully, if the country they're sitting in will permit them, become part of that community and just locally integrate. Only in extraordinary cases where there's either a family member already in the U.S. or they're in some sort of danger, does a person even qualify for resettlement, referral to the U.S. resettlement program, which last year brought in about 85,000 people. The third country resettlement is reserved for those cases that really can't stay in refugee camps. It is not intended as a place where most refugees go. So last year we resettled around 0.5% of the world's refugees. It's certainly a big dent when you see, the overall worldwide numbers. Most countries don't resettle. Most. We also have about 3.2 million people seeking asylum. That number has grown, and that reflects the European refugee crisis that we've been seeing. But only about 26,000 of those people were granted asylum in the U.S. last year. So again, just to kind of keep us an eye on the numbers. So one of the first actions that the Trump administration did take was to pause the refugee resettlement program. U.S. Refugee Admissions happen from just a handful of countries. It happens just for those people in extraordinary situations where they can't stay in the refugee camp. It's open to very few countries and very few people from those countries, but did pause that program for 120 days. The litigation was filed against that pause, but what happened by pausing it was really a stoppage to it. Refugee admissions require about 24 different security and background clearances to be all current at the same time. If any of you deal with getting more than one background check to line up for anything like custody or child safety, you might have a sense of this, right? But try aligning 24 different programs. Some fingerprint checks are good for 6 months, some are good for 24 months, some are only good for 18, and they all have to be ready and cleared and active in order for the person to be issued their travel documents. So the pause really stopped anybody who was in the queue from arriving, and then was redefined in the second ban to allow people who had ties, bona fide ties to U.S. citizen family members or refugee family members here in the U.S. already. So some people have come, but others haven't been able to throw things into chaos for an already perilous situation. We also had the president announce very recently, at the beginning of this fiscal year, that refugee admission levels for the U.S. would be dropped to 45,000 total for the coming fiscal year. So that's a pretty significant drop. We had it set at 110,000 last year. Most recently, there have been a series of announcements last Sunday on October 8th, then again by the Attorney General on October 12th, really turning sights on the U.S. asylum program. There are new policies that are being proposed to identify and crack down on perceived fraud and abuse. The Attorney General gave a speech to the Immigration Court, to the Executive Office for Immigration Review, where he really came out very clearly accusing immigration lawyers of perpetrating fraud on a widespread basis throughout the system. Somebody who's filed many of those claims, deeply resentful of that characterization, because I've never made up anything for a client, and in a position of having to actually listen to these horrifying stories that my clients present day after day about their lives and why they have fled their countries. But that is underway right now. We also have the Muslim ban, which has gotten a lot of attention out at the airport and elsewhere. Currently, there's no ban if you are a U.S. citizen or permanent resident from one of the nationalities, or if you've already been granted asylum or refugee status. There are a number of new countries on the list: Chad, North Korea, and Venezuela. But there are different categories and rules for each of the countries. So it's making travel quite unpredictable. The rules are different for each. Venezuela really only applies to government officials. Somalia is total ban on any arrivals, that sort of thing, case by case. We've also seen a real change in deportation priorities, and this is one area that the Obama administration laid a lot of groundwork for. If you heard speeches over the years of we deport felons, not families. We are continuing that. Now, the one change that we have observed is that people being apprehended by ICE and removed as criminal aliens under that sort of blanket category are people who have convictions, people who've been charged but have not gone to trial or gotten a conviction, so people who've been acquitted, and people who've committed a crime or are alleged to have committed a crime but no charge was filed. Those are all being taken in as priorities, and that's what's escalating the number of folks in detention. We also continue to have real priority for apprehending people who have outstanding orders of removal, issues of fraud, allegations of any contact with gangs. Those remain sort of rhetorical top priorities. But when you look at the deportation numbers, over half of the people removed from the U.S. Or against whom proceedings were initiated are just straight undocumented, here present with no papers, charges. So finally, how did we get kind of to this space where we do have 45,000 people in detention on any given day? When we are a nation of immigrants, right? This is our story. This is our story, and we are sticking with it, right? That we're a nation of immigrants. We celebrate that with our kids in school. We talk about that in naturalization ceremonies. We're proud of that. We here in this building and in the Rathskeller, we like to see how Minnesota's legislature was a multi-ethnic grouping of people.
So the wildlife
reconciling that with this narrative of really criminalizing migration. Part of that is because it's not that simple, right? It really is a gray area of complex issues of settlement, of slavery, of exclusion, and of deportation. Those are parts of our immigration story just as much as the promise of a life in a new land and Ellis Island are. At the same time, Ellis Island was operating to the U.S. Angel Island on the West Coast was operating as a deportation center for Asian immigrants out of the U.S. So we have that tension in our history since the beginning. Our earliest immigration acts really looked at who could be in, right? And the first definition of who could naturalize, who could become, who could affirmatively say, I want to become a U.S. citizen, was limited to free white persons who've been in the U.S. for more than 2 years. That was the benchmark. And it accounts for why, over time, we have Latino immigrants as an ethnicity, not a race, and states like Louisiana and Georgia still have birth certificates indicating that Latinos are white because they were eligible for naturalization over time. By the 1880s, okay, we skipped from 1780 to 1880 with no other immigration laws. But by 1882, we enacted the Chinese Exclusion Act, which was expanded into the Asiatic Barred Zone, effectively excluding from the U.S. anybody from South Asia, Southeast Asia, or the Middle East from lawfully immigrating to this country. We had practically no immigration from Africa, due largely to distance and cost. There was no exclusion, but there was no real numbers. But as immigration patterns began to change from Europe, we began to write in exclusion provisions that are still with us today. Convicts, lunatics, idiots, and public charges. We have updated the language, but we do still have barred public charges. Anarchists, previously deported people, illiterate people. We began to make it a crime to bring somebody illegally into the U.S. And by 1924, we had created a system of quotas, national origin quotas that defined who could immigrate and who could not. Asia, the Middle East, they're out. European migration was reset so that it would mimic the patterns of 1890. In 1924, as more Southern Europeans, more Catholics, more communists were coming to the U.S., that was the fear and the perception. This national origins quotas sought to skew things back to when Northern European migration was the norm. And that was the same year that we granted citizenship to Native Americans in the U.S. And interesting that those coincided that same year. But up till that point, Native Americans were not U.S. citizens. And again, we had a big jump to the law we have today. The Immigration and Nationality Act went with the family-based and employment-based system that I started out describing, it put a worldwide cap on the number of people who could come into the U.S. It created that diversity visa, but for the first time subjected immigrants from the Western Hemisphere to that immigration system. We think about immigration today in terms of the southern border, but in the 1800s, 1900s, we were thinking of it largely in terms of immigration from Europe, immigration from Asia. And Western Hemisphere migration was much more both normalized, accepted, and unregulated. They weren't subject to those quotas or caps. We dealt with our Western Hemisphere nations in a really different way at that point. But for the first time in 1965, they became subject to those caps. And that changed things. Why did we pick a family-based, employment-based system for immigration? It was part of a complicated negotiation. It wasn't race neutral. This was 1965. It's part of the immigration, or part of the civil rights era legislation. But the compromise that was worked out to rely primarily on family-based immigration was one that was really predicated on keeping the racial balance in the United States the way it was. The American Legion applauded the family-based immigration system as primarily a backdoor national origin quota, thinking that white people would marry white people and would continue to bring their relatives and we wouldn't change. That was a driving motivation for the compromise we have in place and what gave us this lovely system that we're operating under today. Some people describe this as broken. I think it's working pretty well as intended, but it isn't serving the same needs that were identified in 1965, which isn't surprising given things have changed just a tiny bit in the 50 years plus since that law was enacted. This criminalization piece is where I want to end up because it is something that's really an issue we're dealing with today and we have been dealing with for some time. In 1980, the U.S. passed its Refugee Act. It adopted that definition of well-founded fear of persecution on account of race, religion, nationality, social group, political opinion. It did that because up to that point, you could get asylum if you're fleeing communism. It was a national, it was granted on a nation-by-nation basis. We had accepted displaced persons following World War II from Europe, about 400,000 displaced persons, but we had no mechanism for dealing with people fleeing for their lives. Created the 1980 Refugee Act at the moment that Central American conflicts were flaring up. And hundreds of thousands of Central American refugees started coming to the United States. The U.S. immigration officials in Arizona and California and moving, throughout the U.S. Really did not take to this definition, and were driven in large part by fairly political motives in the adjudication of those early claims. And that gave rise to the sanctuary movement. There's been so much talk of sanctuary in the current discourse. There's been a lot of examination of what happened back in the 1980s, and some really good historical information has been brought out, especially in some podcasts that have been quite explicit about how they created this sanctuary movement because the U.S. wasn't adjudicating asylum claims. Right? 97% of Salvadorans who applied for asylum in the early 1980s were rejected. 97% of people who were fleeing persecution at that point. And this decision was something that the immigration authorities really took to, they embraced, and they, instead of recalibrating the decisions on asylum, went in to criminalize the folks who were working on those cases. And we started to see a lot of laws, just a cascade of laws throughout the 80s and 90s expanding grounds of exclusion and deportation. Throughout 86, 88, 90, 94, and 2 laws in 96, we expanded the ways we could deport and detain people in the U.S., increased penalties for bringing people in, clamped down on smuggling, increased border patrol at that point, and really got to a place where by 1996, we had retooled the enforcement side of the immigration system. And we've stayed with that since that point. It has led to a place where we view migration as a criminal act. And that is something that is out of step with the system we've designed to enforce it. It's not a criminal legal system. These are civil charges. It's a system that does not afford a speedy trial or an attorney or any of the constitutional protections against self-incrimination that we rely on to keep our system of justice working. And it is causing stress out there in the community. I think we have a chance to get back to a system that works for the U.S. I don't think it's the 1965 Act. And from a human rights perspective, we hope that it's one that will be balancing both our interests as a nation and our sovereignty interests and the rights of the people who are affected by that system. So it's 1 o'clock. It is time to go. You've all been silent. I'm sorry for that as I keep rolling through. But if you do have questions afterwards, we can stay by the typewriter, and we can also, the typewriter. I said that out loud. By the computer, which is hooked up to the internet. And I can also take questions, but I know many of you have to get back to court, so I really appreciate your time and attention, and thank you for all your work.